Lewis, Michael Dagger Margozzi, or Dave McCready appearing. Are you on this one, Mr. McCready?
Yes.
All right. Dave McCready appearing on behalf of the people, and Michael Dagger Margosian appearing on behalf of Mr. Lewis. We did have Mr. Lewis tested today. Mr. Coast, could you please report as to the results, please?
Judge, he did test positive for 3 substances, Suboxone, marijuana, and also meth. He did indicate that he is using marijuana, also that he used meth just last week.
All right, so Mr. Dagger Margosian, your client is charged with 1, 2, 3, 4, 5 counts of delivering, manufacture of methamphetamine and maintaining a drug house. So, and now he's admitted to use methamphetamine a week ago. You know, Mr. Lewis, you're facing 20 years in prison, and, you know, evidently you have a trach, which, you know, I could still put you in jail for violating your bond conditions. Do you understand that? Use your words, speak. Okay, he said yes, he can't speak. Oh, okay, speak. So at this time, Mr. Dagger Margosian, his bond conditions are that he is to test and he is not to use illegal controlled substances. One, he hasn't been testing. We'd like to set him up for testing, but I have some grave concerns about continued use of methamphetamine and Suboxone.
If I may address.
I don't know, you test positive for it. Can you stand at the microphone? Our recording. I know, but hold on, let Mr. Dagger Margosian speak for you, please.
Judge, I guess let me just address kind of everything that's happening. Number one, I have been provided, as I was provided in district court, images of Mr. Lewis's prescription meds. I certainly can provide that to the court as well as Mr. Coast. The prescriptions being alprazolam and Xanax. I would have to do a little further research as to if that would account for what was accounted for today in the test. But additionally, as the court is aware, Mr. Lewis did speak with the district court probation department, which would be doing the testing requirements in district court, and it was determined because of Mr. Lewis's health and lack of reliable transportation that he at that time was not required to do testing. And maybe it's because this was not a possession but a sale charge. I think that may impact the decision to whatever the court wants to put weight on that. So at this time, I guess I would have a couple of questions. Number one, certainly if the court wants him to test, that's of course the court's prerogative. I would say that based on what I have presented to the court, that I would ask that he continue with the bond conditions as it is now, which is to not be required to test because of transportation.
Well, he can get transportation to get meth, so I don't think he's having too many issues.
Well, again, Judge, I would want to look a little. I understand what the results show today. I would want to look a little further, but regardless of that, he does have support in court. I can I can definitely speak to his support to see if there is any way that we could accommodate the court in these bond conditions. But ultimately, there has been a resolution extended by the people. I just need a little bit more time to speak with Mr. Lewis on that matter. So that's what I can present to the court.
If the people could be heard, Your Honor.
Yes, you may be heard, Mr. McCready.
Yeah, thank you. I mean, given the clear violation of his bond conditions, we would ask that the bond be revoked. In this case, he sold to a Rhino officer directly 5 times, I believe, 4 or 5. He was caught with a large amount of methamphetamine, and he admitted to being a drug dealer. So it's basically an open and shut case. His guidelines are 24 to 40 months, so this is going to be a prison sentence. I understand that he's not a young man and he is ill, but that's probably what you should consider before you engage in this level of drug dealing. So he might as well start serving his time now. Any time that he serves.
Listen carefully to what the prosecutor is doing here. He's not just talking about today's failed drug tests, reminding the court about the entire case, the repeated drug sales, and the seriousness of the charges. It's a strategy designed to convince the judge that keeping this defendant out of jail is simply too big of a risk.
Or, if he can't make bond, be credited toward his prison sentence. But that's the end result of this case, I believe.
Looking for his bond conditions. Sometimes they give them me, sometimes they don't. Just for discovery. I don't look for bond conditions. Mr. Daggerman goes in. Register of actions. Bond conditions, 2 times a week, drug testing. It's been so long, Miss Spade, what is on I can't remember.
Regular and random.
Testing and SNS.
Search and seizure.
Search and seizure. Defendant must report. Manufacturer check-in. Do not leave. Okay, here we go. All right, so his bond conditions: not to use or possess marijuana, cocaine, heroin, opiate, or any controlled substance. Immediate arrest, revocation of bond, drug testing 2 times a week. All right. Okay, so Mr. Daggermer goes in. I don't know how this case will get resolved at the end of the day because I'm not the attorney. I don't know whether he's facing a prison term at the end of the day or not, but at the end of the day, he has multiple serious charges involving methamphetamine. And at this point, he has violated his bond conditions by testing positive. Obviously, Mr. McCready is asking for his bond to be revoked at this time. But if I don't revoke it, your client's going to be required to test 3 times a week at this point because of his use. And he's going to have to do that. If he can't do it, then he's going to go to jail. And so he either is going to find transportation or not. So is he going to be able to test 3 times a week?
Yes, I mean, compared to the alternative, yes, you will find.
Okay.
Yeah.
So I am going to amend his bond conditions. If you test positive again, I understand marijuana is going to stay in your system, but I don't want you smoking weed either at this point because of the nature of your charges.
Judge, Mr. Lewis is extremely limited. Obviously, what the court may not know is in the course of this investigation, because it was a drug transaction allegation, his car was seized, and so he doesn't have transportation. But if the alternative is staying out of jail, Mr. Lewis is going to find transportation. He will have.
This may be the biggest suspenseful moment of the hearing. For a second, it sounds like the defendant is about to lose his freedom completely. Then the judge pauses and considers another path. Courtrooms often come down to decisions made in moments just like this, where one sentence can completely change someone's future.
We're not
From Cement City to the drug testing facility, I don't think you're gonna be able to do that. Okay, I'm gonna remand him to custody of the sheriff's department. I'm gonna set this over.
Well, can I just approach Judge?
I can't because the prosecutor can approach.
Yes.
All right, so I'll do this. I'm gonna set this out 2 weeks. I'm gonna order 3 times a week testing. I'm gonna put you on house arrest. You cannot leave except a drug test, come to court, or go to the doctors. Do you understand? And if you say yes for me. Okay, he said yes. If you violate those bond conditions, I am gonna remand you. Do you understand? And I'm gonna set this over, Miss Adams, am I available on July 8th?
Judge, you are here. I am not, but I can prepare paperwork ahead of time if you need.
Are you here July 9th?
No.
Oh, you're killing me. Are you here July 7th?
Yes.
Okay, so I'm gonna set this over to July 7 at 8:15. Is that all right, Mr. Dagger-Margosian?
Yes, Judge.
So I'm gonna set it over to July 7, and Miss Adams, can I get him a notice of hearing? So I'm gonna set this over to July 7 at 8:15. Mr. Coast, do you need to talk to him today?
I do, Judge. I need to go over the colors with him so I could meet
All
him
right.
out in the hallway.
And then Miss Adams, I'll send Miss Awad back for a notice of hearing for July 17 or July 7 at 8:15 in the morning. Mr. Lewis, if you haven't tested as ordered or violated your bond conditions, you're gonna go into custody that day. Do you understand that? All right, he nodded his assent. So we will,
No substances.
no marijuana, no methamphetamine, no Suboxone, unless you have a prescription for it, nothing illegal or marijuana.
And Mike, if I could get copies of those prescriptions from you this morning.
Sure.
Okay.
Okay,
Everything changes once a plea agreement enters the picture. The courtroom is no longer focused on proving guilt. Instead, the judge must make absolutely certain that every right being waived is understood. Every yes, from this point forward, carries enormous legal consequences and becomes part of the official record forever.
go ahead and join that. All right, so, we are going to have to make some accommodations for audio. So, he's either gonna, if we can move the table mic close to the podium. No, we're not gonna be able to use the table mic with him. He's gonna have to stand with her. And then, but move it closer to the podium and make sure the mic's right in front of him. Mr. Lewis, this is file number 2026-22651FH in the matter of the people of the state of Michigan versus Lyle Lucky Lewis. I have Dave McCready appearing on behalf of the people. I have Michael Dagger-Margosian appearing on behalf of Mr. Lewis. I do have a signed advice of rights. Thank you for that. I also have Darren Coast here from the probation department. So the plea agreement that I've received states that Mr. Lewis is going to plead to an added count 7 attempted delivery, manufacture of methamphetamine. And what's the maximum penalty on that?
10 years.
10 years. All right. So, and there is a Killebrew agreement, I guess, would be that Mr. Lewis would be sentenced to 24 months to 10 years with the Michigan Department of Corrections. And that, he's obviously entitled to any credit he has. I don't know how much credit he has, but, and there would be no further testing pending sentencing, but he would be on house arrest where he can't leave except to go to court or to the doctors. Is that correct, Mr. Dagger-Margosian?
All of that is correct, Your Honor.
All right, Mr. McCready?
And
other counts would be dismissed along with his habitual offender.
right, the bond modifications aren't part of the sentence, the plea agreement, but the other parts of it that the court indicated yes. And I believe the court has said you're going to do that on your own.
Okay, so yeah, yeah, all right. So, Mr. Lewis, I recognize you have some difficulty speaking loudly. We've moved all the microphones, and because we have to record these proceedings for appellate purposes, I'm going to need you to do your very best to speak as loudly as you can, okay? So, could you say yes or no?
Yeah.
Okay, and his response was yes, and I guess Miss Spade to help with that, I will verify his responses as
Thank
well on
you.
the record. So, Mr. Lewis, can you raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, and you responded yes. So, Mr. Lewis, you can put your hand down. So, Mr. Lewis, you have heard my statement, as well as the agreement by your attorney and Mr. McCready. Is it your intention here today to plead to an added count 7, attempted delivery, manufacture of methamphetamine, which carries a maximum penalty of up to 10 years in prison, with a Killebrew agreement that you will serve 24 months as a minimum to 10 years? So is it your intention to plead guilty to that today? All right. So, Mr. Lewis, are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you? Okay, you have verified yes. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence in terms of, any other conditions with the court. Is that correct, Mr. McCready?
That's correct.
Mr. Dagger Margosian?
Correct.
And is that correct as far as you're aware, Mr. Lewis? In fact, the only discussion we had was a sidebar regarding whether or not he would be required to test as a bond condition pending sentence, and the court on its own said, I would not require that, and Mr. McCready objected. Is that correct, Mr. Dagger Margosian?
Well, I don't think he objected. I think he's just not taking a position.
Yeah.
That's correct.
Okay. All right. If the guilty plea is accepted, there will be no trial. That means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that your plea? It's okay. You good? Okay. All right. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, sir? Okay, and he verified yes. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that? Say it again for me. Okay, he verified yes. Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you? And he verified no. Mr. Dagger Margosian, am I correctly restating when I verify his responses?
Yes, and if there's ever a misunderstanding, I'll let the court know.
Thank you. All right, and we understand for medical purposes, it's very hard for you to speak loudly. All right, so your response to this will be guilty or not guilty. So how do you wish to plead to the charge that on or about the time period between December 1 of 2025 and February 3rd of 2026 in the village of Cement City in the county of Lenawee, that you did commit the offense listed in count 7, attempted delivery manufacture of methamphetamine? Guilty or not guilty? And his response was guilty. Has anyone made any threats or promises to you to induce you to plead guilty to this charge? And his response was, no, we can hear it, but our recording system doesn't pick it up. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that? His response was yes. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. McCready?
Not aware, no.
Mr. Dagger-Margosian?
No.
All right, and there is a Kilbrew agreement, so the court will comply with that. Is it your own choice to plead guilty? And his response was yes. So, Mr. Lewis, during the time period of December 1 of 2025 through February 3rd of 2026, we're in the village of Cement City in the county of Lenawee? His response was yes. Did at that time you have in your possession methamphetamine? Yes, he responded yes. Is that correct, Mr. Dagger-Margosian?
Correct, ma'am.
All right, and did you attempt to deliver that and sell it to somebody else? Okay, so his response was he didn't deliver it, they came to you. So under the law, delivery means you sold it or gave it to somebody, so it's confusing. So did you in fact sell that or give it to somebody? Okay, and in fact it was Rhino, my understanding, Mr. McCready?
Right.
Okay, all right, and are you satisfied with the plea?
Yes.
All right, I accept the plea, or has the court complied with, wait a second. I'm looking at the wrong one. All right, has the court complied with MCR 6.302 B, C, and D? Mr. McCready?
Yes.
And here it is the moment that officially changes the course of the case. By accepting the guilty plea, the judge closes the door on a trial and moves everything towards sentencing. But don't think the story is over. The biggest question is still waiting to be answered. How severe will the final punishment actually be?
Mr. Dagger-Margosian?
Yes.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement on its own in terms of a Cobb's agreement regarding the possibility of a plea or possible sentence, but there is a Killebrew agreement that was struck between the prosecutor and defense counsel, and I will honor that. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Adams, once again, can I get a notice of hearing for sentencing? And Mr. Dagger-Margosian, are you available on August 7 at 8:15 in person?
Yes.
All right, so I will, and Mr. McCready?
Yes.
All right, so I will set this for sentencing on August 7 at 8:15 in the morning. I will cancel the July 7 pre-trial, so August 7 at 8:15 in the morning, and we will get you a notice of hearing, so you have a copy of that for that date. Mr. Lewis, when you leave the courtroom after getting your notice, I need you to step across the hall to the probation department. Check in. They're going to give you a date and time that you got to come and meet with them. When you meet with them, be truthful about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide a copy to Mr. Dagger-Margosian. He's really good. He'll reach out and review that with you on the phone or send you a copy. And we'll see you back here in person for sentencing on August 7 at 8:15 in the morning. All right?
Judge,
Yes.
so what is the bond conditions then?
At this point, it's a house arrest. We're going to remove the testing requirements.
Thank you.
Oh, I thought we did, but okay. So, Mr. Lewis, just for the record, when these officers came to your home, you sold them methamphetamine or attempted to, correct?
Yeah.
And his response was yes.
Thank you.
Is that a mistake?
Yes, thank you,
Okay.
Judge.
All right. So August 7 at 8:15 for sentencing.